bank actually received the notice and did nothing. That what the content of the notice is prescribed by statute. Then, at least a minimum of no less than 90 days later, a notice of sale must be recorded and sent to the parties in interest, including junior lien holders of record like the bank. And here there's evidence that the bank actually received the notice, was mailed to and received the notice. And the content of those notices is prescribed by statute. And finally, how the sale is to be conducted is in the statute. It has to be publicly noticed. It had to be posted in 3 places. It had to be published for 3 weeks in a row. Had to be held in the notices had to say where it was taken, in a place that people could attend, and at what time.
Are there any cases that apply commercial reasonableness to the foreclosure setting beyond the extent to which you have sort of the Long versus Town unfairness, oppression, or fraud plus grossly inadequate price metric? In other words, does that doctrine add anything analytically to the statutes you've just described and the equitable cases?
I don't believe so, Your Honor. What you look at is they're similar. What you have is a similar concept. In other words, you take the statute, and if everything was done by the statute, and there was no fraud, oppression, or unfairness in the process of the sale itself, the conduct of the sale, and the cases that look at what designates that, this court actually looked at. But you look at, was there fraud, oppression, or unfairness as to the conduct of the sale? And then you take that with the price, and this court looked at the potential of grossly inadequate price, but didn't adopt that as a measure in and of itself. Golden, Long v. Town, both have rejected gross inadequacy of price in and of itself. And there has to be the two combined. And if there is no evidence of anything like that, then the sale should not be set aside. And when you look at some of the out-of-state cases, or even some...
That's what I'm asking about. Are there out-of-state cases that treat those as separate?
No, I think they all look at it as inadequacy of price or gross inadequacy of price, plus there are a few jurisdictions that look at it as simply saying shocks the conscience, but this court expressly rejected it. Arizona, I believe, rejected, but this court has expressly rejected that standard, and Golden v. Tamiyasu. So it's the combination. It's similar. I'm just saying that what you would look for commercial reasonableness is prescribed by statute. In other words, how was the sale conducted? And then you look at, was there anything that impacted that sale, that accounted for the price, which is what was discussed in the California decision, where we in Golden, where we adopted the standard to begin with. I think they're very similar. What you're looking at is, because you're not changing the type of product, you're simply looking at what was how was the sale conducted, and that's prescribed by the statute. You don't have to look at a difference between perishables and durables.
Ms. Cooper, just one question. I was looking at the findings by Judge Katie. So she indicated in finding 5 that the foreclosure agent received a recorded copy of the notice of delinquent assessment. So was it clear in the district court that there was notice to Mr. Wiles' clients directly or indirectly through an agent? Was any type of disputed fact raised?
No, there is no disputed fact at all. As a matter of fact, if you look at page, when we talk to agent, we're talking about the recorded, the people on the deed of trust. If you look at
the beneficiaries, or who
yeah,
is
the beneficiaries on the record, and here, actually, maybe Federal Credit Union was the lender and the beneficiary on the deed of trust.
Okay, and it says they received a copy of the notice by certified mail. So that,
yes, and that's on,
okay.
And that actually can be found on page, I believe, 54 of the record for the notice of default, and on page 64 and 65 of the record for the notice of sale.
Okay, thank you.
So we have actual notice. We have a bank that did nothing. And so, and they were given 56F relief specifically to look for fraud, oppression, and unfairness. I understand this is a pre-Shadowwood case, and a pre-Shadowwood order. But the district court did exactly what you would have expected, which is, was this a fair sale? Was there fraud, oppression, or unfairness? Are there any facts that even suggest it? And in the absence of any facts such as that, then there's no reason to do a Shadowwood balancing analysis. There is no evidence. And therefore, they cannot show that their deed of trust survived or should survive this sale in any way, shape, or form, or that the sale should be unwound.
I think your opponent's argument is that the uncertainty in the legal landscape depressed price values at these foreclosure sales to such an extent that the sale was inherently unfair. I don't think he articulates it quite that way, but that's kind of what I'm understanding. Could you comment on that?
Yes, Your Honor. What happened, I believe, is, and if you look at this, now you're looking at something like a BFP, the Resolution Trust. You know, what was this a reasonably, reasonable price for a sale? When you look at all the circumstances surrounding it, it's a forced sale. The legal landscape, reality is what the law was at that time is what the law was. And I think as this court put it pretty succinctly, a mistake in the interpretation of the law does not relieve them of their duties to protect their interest. Obviously, that wasn't the exact language.
We have had some cases, to follow on to Justice Kennedy point. We've had some cases here where there's been trouble trying to identify whether there was a sale of the super priority interest, the dues owed on the super priority interest, or whether it was dues that went beyond that. It was unclear whether there was interest accumulating. It was unclear whether there were attorney's fees being charged. In the context of these sales, pre-SFR and pre-Shadowwood, shouldn't the court take those issues into consideration? I'm not sure that even the HOAs knew what they were selling before those cases.
Your Honor, I would respectfully disagree that the court shouldn't take them into consideration unless there is specific facts before the court to suggest that there was a problem or a dispute between the HOA and the lender, and then whether or not the seller or the buyer would have even known that.
So your position would be that given the uncertainty of the landscape, the lender who got notice should have at least inquired.
I think they should have inquired, and as this court put forth in SFR, they had a number. That wasn't the only thing they could have done. They could have paid under protest. They could have paid without reservation. They could have requested. They could have come to court the same way that many of the purchasers had to do, was come to court and get an injunction to stop the sale. So they could have said, hey, we're having problems. Let's go to court, get an injunction, stop the HOA from selling this, because there's a possibility that we could be wiped out.
I have a question. It seems to me fairly clear textually if you don't have the Shadowwood problem of the lender having bought the property at the sale and then become in effect the owner, and you get complicated on the math in Shadowwood. But this was a straight up lender, first deed of trust holder. And so the statute says they've got a super priority lien to the extent of 9 months of the HOA dues, whatever they are. Was there any effort to tender the 9 months and say, hey, go ahead with your sub-priority foreclosure, but we're paying you this and you need to stop. You don't have the right to foreclose?
There is no evidence in this record, and they brought forth nothing from their records to show in any way, shape, or form that they acted on these notices at all.
So there was no tender, no argument about tender, no, they didn't say, here's the money, HOA, that you need to, for your 9 months of dues?
No, Your Honor.
Okay.
There was nothing.
So this is not a tender case?
This is not a tender case, and to the extent that the law was in flux at the time, to be clear that while this was an early case, the sale actually in this case took place in 2013. This is after the NRED decision. had been come out, the in-red opinion had come out, after all the litigation was going on, and quite honestly, to take into account that there's a flux in the law, or people don't know what's going on, and yet they're creating the very climate under, for example, BFP Resolution Trust. They're creating the climate. The banks were litigating, does this statute even apply? Is there even a super priority lien that takes priority? They're litigating this, and then they want to complain about the prices when people have to take into account that they're probably going to have to go to court to defend what is their statutory right. And I don't think you get to use it as a sword and a shield. Quite honestly, this court interpreted SFR as it existed. The law, it wasn't new law, it was the statutes as they existed that day. And that's, therefore, there's no question. That's what the law was.
What would the tender amount have been? Does the record show that?
The record doesn't show that, Your Honor. But again, there was no effort at all on the part of the bank. At least there's nothing in the record at all on the part of the bank to show this. And remember, they had 56F relief to show that they could have whether or not they would be able to have some evidence of fraud, oppression, or unfairness.
So the bank didn't contact the HOA at any time to ask for a payoff amount on the super priority?
The bank, in its own records, could have brought forth evidence that they did that, and they brought forth nothing. The only thing they complain about here, other than, well, the notices which are required by statute don't tell me something, and post-sale conduct that has nothing to do with the actual sale and the conduct of the sale itself. So there's nothing in this record. Remember, these are records they would have had in their own possession and wouldn't have even needed 56F relief for, because they should have brought it out in the beginning if they had made a tender. They should have looked in the records at the first motion for summary judgment.
Was there any argument ever made by Navy Federal Credit Union that they're federally organized credit unions of federal law should apply to transactions that they enter into? Did that ever come up?
Honor. They didn't make anything like that, and as they said, they have waived now the supremacy argument. So there was
the supremacy clause argument, but that's been withdrawn, right?
Correct, Your Honor. So in this case, there is no evidence post 56F relief. While the court said there is nothing, no commercial reasonableness, they actually took the Shadowwood standard and said, was it fraud, oppression, or unfairness that you can bring the evidence of, and they didn't. And to simply say we didn't know for sure what the law would mean is not enough to say that that is unfair. Because there were steps, they had actual notice, they were sent the notices as required by statute, and they took no action whatsoever, not one of the steps that this court laid out in the SFR decision as a possibility to even try to protect their interest. I think this is simply a case of a bank or a lender sitting on its rights and ignoring a notice that its collateral could be gone. Thank you, Your Honor. We've asked you to affirm.
Any further questions? Thank you. Well, you have 2 minutes and 50 seconds.
Mr. Wiley, can I ask you this, in coming back after hearing Ms. Gilbert's argument? Now, let's say we agreed with you that there was a genuine issue of material fact here regarding the sales price and all that. What exactly would you ask Judge Kadish to do? It sounds like nothing's been raised by your client on anything other than the sales price. So what is it that we would send back to Judge Kadish to consider?
I think my client should be given the opportunity to subpoena the HOA agent that cried the sale for the trial, and
what would that potentially show? If you're making an offer of proof, or what would you say? I mean, how's it going to change this case?
Well, we do have the accounting that is part of the record, and we would ask them what part of the lien that they were trying to sell, whether it was a priority lien or a sub-priority lien. Again, this is all done in the backdrop of the Rule 56 motion, and we would like we would like an opportunity to put evidence into the record at a trial to see exactly what they were selling. There's been a lot of discussion of fairness here, and I understand that's a wide net.
But if your client never made a demand before the the sale to the HOA to provide you this information. Isn't it a little late at this stage of the game to be asking for that?
It would be from a factual text, from a factual approach, and I agree. As stated, the fairness, it's a wide net, but I don't think at the time this was a mistake and a mistaken idea of what's going on in the law that my client had. And I think a way to look at the fairness issue is to look at the first test under the Chevron case, where the court considered whether or not to apply the law retroactively. And in this case, I'm not asking you to make that decision today. I think that you should wait until that's fully briefed and argued.
Does Chevron apply to interpretation of pre-existing statutory text?
That's correct. And that's
You believe it does? You believe Chevron applies to interpretation of pre-existing statutory text?
Yes, I do, and I think that looking at that, nobody could have guessed this. And again, that's my position. Others might argue.
Understand.
But this court itself was split in that SFR decision. That was a 4-3 decision. The lower courts are split. I would estimate approximately 50-50. This court is split with the federal court on NRS 116. And again, finally, the Nevada legislature in 2015 completely revamped the statute. Thank you.
Thank you, Ms. Gilbert and Mr. Wild for your arguments in this matter, and this case stands submitted.
Thank you.
All counsel's getting ready. The next case is case number 69400.